All right, good morning, everybody. We're back in session. Welcome to an oral argument session of the 5th District Court of Appeal. My name is Dan Traver. We're being broadcast live and recorded on YouTube this morning. This is our second of 3 cases on our oral argument calendar today. It is Christopher and Madeline Peterson versus University Property and Casualty Insurance Company, case number 20-862. I'd like to introduce my fellow panelists. I'm joined today by Judge Rand Wallace and Judge Mary Nardella. Mr. Hubbard, I will assume that unless you tell me differently, that you'd like 5 minutes for rebuttal, and you may proceed at your leisure, sir.
Thank you. Good morning. May it please the court, Robert Hubbard from the Vaca Law Group on behalf of the appellants, Christopher and Madeline Peterson. This appeal arises out of a first-party property insurance coverage dispute involving 2 underlying fire losses that occurred in August of 2010. Because genuine issues of material fact exist regarding whether the Petersons resided at the property within the meaning of the residence premises provision, the final summary judgment entered in favor of the insurance company must be reversed. The insurance company has relied almost exclusively on the Arguelles versus Citizens case. So I'd like to begin by explaining why Arguelles is factually and legally distinguishable and how it actually supports our position. In Arguelles, the property was a condo in Miami. The named insured obtained a policy from Citizens and resided at the property for about 10 months. He then moved to New York, accepted a full-time position there, and started renting the property in Miami to 2 tenants. The trial court ultimately granted summary judgment after there was a water loss at the condo under the residence premises provision. And the court held that the language of that provision required the insured to reside at the property. And because the named insured had, quote, established an abode in New York, and because the condo was solely occupied by tenants, as a matter of law, the court was able to make the decision that the insured didn't reside at the property, and therefore the property didn't constitute the residence.
I think I understand where you're going with this, Mr. Hubbard. I think yes. One of the challenges that I'm having with your argument is your client's testimony that she was leasing out the property for 7 months before the fire incident. And I recognize that she may not have been collecting rent, but it seemed at least arguably clear from the record that it was a landlord-tenant type relationship, which seems to be analogous to the 3rd DCA case. And I know you were getting there, but I wondered if you might address that particular testimony for me. Sure,
thank you. And I'm going to push back on the idea that this is a typical landlord-tenant arrangement. In the Arguelles case, the language that the court used was that the property was solely occupied by the tenants. You think of a traditional lease, the landlord surrenders possession and control, all their possessory rights in the property to the tenant. You're now under Florida law abiding by a new set of requirements about giving notice before you can access the property. The tenant has its right to enjoyment and all of the things that they can do without the owner of the property interrupting those issues. Here, what you have is a situation where the named insureds, they fully furnished the property. Ms. Peterson, during her examination under oath, testified that she continued to live at the property on and off, including at least a 1-month period during the policy term when she and her husband were having marital issues. And so at all times here, the insureds maintained a physical presence at the property. They continued to occupy the property. They simply allowed a family member to stay in one of the rooms while they were there.
Mr. Hubbard, can I ask you a question about that? Is it
yes.
Your position under Arguelles that their definition of residency should not apply to this case, or rather is it your position that the Petersons were living in the place permanently or for an extended period of time, which was the definition the Arguelles court used?
I have no issues with the definitions that the court used in the Arguelles case. In fact, if you look at the Black's Law Dictionary definition of residence, which is one of the definitions that the court relies upon, there's another provision that says a person can maintain more than one residence at a time. It's my position that in this situation, based on the physical presence that the insureds maintained at the property, they continue to use this property permanently and at all times as one of their family residences.
But what about the word to live in a place permanently? Is it your position that their use of the property was living in the property?
Well, when we take a step back and look at the rules of insurance policy construction, reside isn't defined in the policy. And what Arguelles says is, well, that doesn't mean that it's ambiguous. I agree with that. But if you're now the insurance company and you're trying to construe that term as if it means continuous and sole occupancy, or if now the residence premises must be your sole primary residence, that is now adding language and conditions into the policy that just aren't there. And so what we've done is try to differentiate between the issue that the Arguelles court addressed, which is whether the policy requires actual residency at all. The named insured in that case didn't dispute that he did not reside in the property. He didn't have possessory rights to the property. His argument was, well, just because it says reside, that including that language in a definition doesn't mean that I have to live there. That can't be treated like an exclusion. And the court says, no, the word reside is not ambiguous to the extent that it requires some form of residency. And in this case, based on the testimony of the Petersons during the EUO and the affidavit that was submitted, the counter affidavit submitted as summary judgment evidence, our position is that at this point, residency becomes a fact question.
Mr. Hubbard,
yes.
Are you taking the position then that the use of the terms live and reside are inconsistent as far as determining coverage?
I would look at the Florida decisions that talk about residence and household in the context of other exclusions. The word reside, Florida courts have held, doesn't limit one person to one structure. The concept can extend beyond a single household. And so
to live in a building, can you live in two structures at the same time?
Your Honor, respectfully, I would answer yes to that. If you've fully furnished the property, in this case, the Hawkins property, if you've maintained the bedroom there, if you put your TVs in there so you can go over there, and admittedly, it would be probably secondary compared to a primary residence. But if there is evidence that you are maintaining this as one of your residences, whether it's occasionally, intermittently, whenever you're having marital difficulties and you just need some space, then at least within the constraints of this policy, that then creates a fact question as to whether they've satisfied the residency requirement.
But Mr. Hubbard, then don't we get to Judge Traver's issue, which has to do with the renting? And in this case, what I understand to be the record evidence is that Mrs. Peterson had not resided or had not stayed a single night. Let me say that. Mrs. Peterson had not stayed a single night at the Hawkins property for 7 months. She had rented it out. And if you look, and this is what I understand, please correct me if I'm wrong, but the record evidence shows that the total time that they owned this home, the Hawkins property, Mrs. Peterson, there's no evidence, I don't believe, correct me if I'm wrong, that Mr. Peterson spent the night after the house was willed to them. That it was solely Mrs. Peterson spending the night, possibly one of the children that would come with her. Okay. Mrs. Peterson, for the totality of the time, I believe it's 7 years, stayed the night at most 3 months, which would be less than 4%. And other large periods of time, she is letting people live there in exchange for money. How does that fit within the definition of to live?
Well, I want to respond about Your Honor's recitation of the testimony. I think there is a slight distinction if you look at the questioning at the examination under oath. For both Mr. Peterson and Mrs. Peterson, the questioning begins with, when did you live at the property, Mrs. Peterson? When were you there? And then it transitions to, well, when have you been separated? So, I mean, I don't think that the record is clear that the only times she has stayed there are during these long periods of separation. Mr. Peterson actually denied calling it a separation. And separately in the record on page, I can find it, I believe it is 316. She's talking about the personal property that is in the home, actually 315. And she was asked, why did you buy TVs in 2009? And because she would say, well, when I stay there, I would stay there off and on. And so we're going into the policy period. Off and on to me isn't a 1 month block of time that she stayed there for a lengthier time when she was separated, but that there may have been other points in time when she used the property. On the issue of rent, again, this isn't the situation where they're relinquishing their rights to the property to a tenant. This is a family member who is supposed to be contributing for a room. When asked whether he had contents in the property, she mentioned maybe some clothes. At all times, the Petersons had a key to the property. They would go by multiple times a week to check on things, to visit the property. Within a week of the fire loss, Mr. Peterson said that he would have been there. I think he started to say maybe on that day, but then took a step back to say, well, it would have been that week because he would check on this house and the other house in the area at least multiple times a week. And there's testimony that they never vacated the property. If your intent is to establish your sole exclusive residence at another location, a reasonable inference would be that you would take your property out of the residence, move it to your sole residence, and then the tenant can come in, bring their own stuff, and now that's their property. In this situation, if you look at the decisions from courts in other states, they've drawn a distinction between whether there's a residency requirement, and then, well, what does the policy require when it comes to the extent to which the insureds have to be present in order to satisfy that requirement. And in the FBS case, probably not the most sympathetic insured in the world, but he was incarcerated for 8 months. And this was Illinois District Court. And although the court goes into some statutory issues that certainly don't apply here because it's Illinois law, the rules of insurance policy construction are pretty uniform. And the lack of a definition or an explanation in the policy or any language suggesting that you have to maintain a continuous, I want to make a distinction between physical presence, because there was physical presence here in the sense that they continued to occupy it with their things and visiting, but using it as an exclusive residence. If that's what the insurance company wanted here, the Georgia case, Kephart, gave an example of language that could have been added to this policy that would have made that clear and unambiguous, and then we wouldn't be here today. The language of it was a special policy provision that provided, quote, the residence premises must be the only premises where the named insured or spouse maintains a residence other than business or foreign properties. That's the language that could have been added in this situation that would take this out of the context of becoming a fact question in line with the other Florida decisions that deal with residency in the context of exclusions. That would have been clear and unambiguous. And in this case, if you're trying to say that this was one of your residences as opposed to your sole and exclusive residence, there would not have been coverage. The Lundqvist case is another Illinois decision that I think is more factually on point. The insureds had purchased a new home they had moved into that new home. They were in the process of selling the insured property. They still had furniture, weight room equipment in the property as it was in the process of being sold. During a period of several months, they had gone back and for at least one overnight stay. And the court said that, in the absence of a definition that clearly establishes that this must be your sole residence, then that's at least enough to raise a fact question as to whether you've satisfied the residence premises definition. And so, going into several of the other Florida decisions that have dealt with this in the context of the exclusion, the language that's typically used in exclusions is whether it's in the liability section of policies where there's no coverage to the extent there's an injury to residents of your household. The Alava case explicitly said that the policy doesn't define residents as continuously living in the same household. There are numerous instances where courts have recognized that the concept of residency requires looking at the person's intent, and it's a mixed question of law and fact. That's what this court held in the blast ban case. And there are factors that the jury can consider when they're reaching that conclusion. Blast ban, the court said that the question was properly submitted to a jury. And in this case, based on what is consistent use of the property, albeit as a second home, that, in our view, would satisfy the definition of residence premises, and the jury could reasonably conclude, based on this evidence, that the Petersons continued to reside in the property throughout the time of up until the point of the loss.
You've got about 3.5 minutes left at this point. You can keep going, but if you want to save something for rebuttal.
Thank you. I do want to make a brief point about why is this issue important. This goes beyond just this single case and these specific facts. If you look at the policy form and where you find this residence premises definition, this is an ISO form. It's a standard form that appears in many policies, not just Universal's. It was in the condo policy in Arguellas. It's used in HO3 policies. And so there are insureds throughout the state that are currently paying premiums on policies that might not provide coverage if something comes up and there's a temporary absence from the property. Thinking of the insured who maybe goes into a nursing home for a period of time. If they're not staying in that property when something comes up and they need to leave, if they, under the insurance company's definition, where they strictly must reside in the property at all times as their sole residence, then that individual wouldn't have coverage. The same for snowbirds and seasonal residents, members of the military, and other unexpected temporary absences. Life happens and things come up. And if there's nothing explicitly in this policy that would say there's no coverage in this situation. And if there are no other questions, I'll reserve what time I have left.
All right. Thank you. And Mr. Labian, correct me if I mispronounce your name. You may proceed.
Thank you, Your Honor. May it please the court, Andrew Labby on behalf of Universal Property and Casualty Insurance Company. We would respectfully request that the court affirm the decision of the trial court, as there are no genuine issues of material fact. And I do want to go through a timeline because I think it's important, and Your Honors did touch on it. But so 1996, between 1996 and 2007, the appellants resided at a property on West 16th Street. During that time period, in either 2002 or 2003, is when they inherited the Hawkins property. And what the record establishes before the court is that for a period of time, the Hawkins property was unoccupied. It would just be used by family members when they needed a place to stay. Then from 2004 to 2005, the property was rented to Mrs. Peterson's sister. She lived there. She paid rent for a year. Mrs. Peterson then lived there for a period of 2 months in the spring of 2006 when she was separated from her husband. But then from that point in 2006 through 2009, the property was then rented to her brother Rocky, who lived there with his girlfriend and paid rent. Then in January 2010, Mrs. Peterson lived there for 1 month, again, when she was having some domestic issues with her husband. And then in February 2010, through the date of loss, the property was rented to another of Mrs. Peterson's brothers, Timmy, who lived there with his girlfriend. And there was an agreement to pay that they were going to pay $300 a month in rent. Now, apparently there were some issues and he may not have paid all the rent that was due, but it was a rental property. So despite how the appellant's counsel has been couching the property in this case, it was not a second home for the appellants. They never resided at that home. It was at all times it was used as a rental property. It was a rental property that they furnished, but that doesn't take it out of the realm of a rental property and make it into a residence. It was not so, and we also don't have a situation, Mr. Hubbard ended by saying, this could impact other insureds who are temporarily absent from their homes. We don't have an issue where it's a temporary absence here. They were never living there. They never lived there with any kind of permanency or consistency. And actually, Judge Nardella, as you said, it was about 4% of the time since they owned the home that Mrs. Peterson lived there. There's absolutely no record evidence that Mr. Peterson ever lived there. Since 2007, they were living at Majestic Forest Run. That's where they got their mail. That's where they got their bills. That was their home. And it was a rental property that was being used at all times. The only evidence that they submitted in opposition to the summary judgment below was an affidavit that said that they had a key to the property, they had access to the property, they had furniture in the home, and they maintained a bedroom in the home. And respectfully, those facts could be true of any rental property anywhere in the state of Florida. I mean, I assume that anyone who owns a home and rents it out has a key to the property, has the ability to access the property. Plenty of houses, rental properties are furnished. None of that means that they're living at the property. They clearly are not. And if we adopt the appellant's position with regard to the term residence, it really has no meaning at this point because at no point in time were they ever living at the property. And similarly, he argued that, they would often check on the property. Again, simply checking on a rental property or checking on a home that you own does not mean that you live there. There is absolutely no evidence that they ever lived at the property.
Mr. I have a question.
Yes,
Mr. Hubbard pointed out the difference between domicile and residency. And while you can have, you have one domicile, you can have multiple residencies. What do you think is the hallmark of residency or to live in a place as defined by the Arguilla Court?
Your Honor, I believe that the Arguilla Court, the residence definition that they use, which would be to either live in a place permanently or for an extended period of time, I believe that is a good definition. I do think that it's not capable of any bright line rule or bright line interpretation. It's kind of one of those things like that famous Supreme Court case about obscenity. I can't define it, but I know it when I see it. That's kind of what we have is that, giving reside, it's normal everyday usage. When someone is residing at a property, when someone's living at a property, and we clearly do not have that here. But I think applying the Arguilla's definition, which appellant's counsel conceded that they don't disagree with, they clearly did not live there permanently, and they clearly did not live there for an extended period of time. The record shows that Mrs. Peterson had not lived there for 7 months prior to the loss. And before that, January 2010 period, she hadn't lived there for 4 years. It had been rented out to somebody else for 4 years. So they were not residing at the property, even giving that definition, interpreting it as favorably as possible to the appellants. And also to touch on the ability to live in two places at once, and Judge Wallace, you also brought up this issue. There's another case out of the 3rd DCA, Allstate Insurance Company versus Gordon. And that's 1978 case, 364 Southern 2nd 44. And what happened in that case is the insured owned a home that was occupied by her mother and disabled sister, but they required a constant caretaker. So the what they did was either the insured or her other sister would be there at all times. So they would do, the insured would be there 4 nights one week, and then 3 nights the following week. And the nights she wasn't there, her sister was there. And the court reversed the denial of a directed verdict in favor of the insurance company and held that under any reasonable view of the evidence, it could not be said that on the date of loss, the policyholder was temporarily residing at the insured property, and that a person may not be residing in 2 residences at the same time. And that when time is split between 2 residences, the policyholder is only residing in the one in which he was occupying at the time of the loss. Now, obviously, the facts in that case were far more favorable to the insured. We don't have a situation here where the appellants were splitting time between 2 properties. Again, they had not lived there for at least 7 months prior to the losses. And during that time period, they were actively renting it to another individual. But even so, at the time of the loss, they certainly were not residing there. And as Judge Wallace kind of alluded to, you just giving it a common sense definition, you can't live in 2 places at once. So I would say that even if there were better facts for the appellants in this case, that you can't be residing in 2 places at the same time. And it's undisputed that they were not residing there at the time the loss occurred. And in fact, the Argelis case, I believe, the facts there could arguably be more favorable for the insured in that case, because he actually, when he purchased the home, that was his home for 10 months. Then he moved out and began renting it to somebody else. In this case, the Hawkins property was never the insured's home. They never lived there. It was either vacant or it was rented to other individuals. So it was never actually their home. They never resided there, except for, again, one 1-month period and one 2-month period where Mrs. Peterson lived there due to some domestic issues. So we're not arguing that it requires sole or permanent occupancy, but what it does require is that you have to reside there on the date of loss, which they did not in this case. And to touch on another argument by Mr. Hubbard, essentially he was saying, well, we didn't have an official or a typical landlord-tenant relationship because she was renting it out to a family member, but it really does not impact the analysis of whether or not they were residing there. She was renting it to her brother. There was an agreement to pay rent. He was living there with his girlfriend. Mr. and Mrs. Peterson were not living there for that 7-month period prior to the date of loss in this case. So there's whether or not they had a formal written agreement, whether or not it was a family member or a stranger, doesn't impact the analysis of whether or not she was actually residing there. And Your Honors, if there is no questions, I would rest my argument at this time.
All right, thank you, Mr. Labby. Mr. Hubbard, you have a little less than 2 minutes left.
Okay, just a few more brief points. I believe counsel's description of what the policy requires is that the insurance company believes the insured must reside at the property on the date of loss. Again, if the definition is that strict, then we're opening ourselves up to situations where temporary absences do become a problem from a coverage standpoint. And that's why other insurance companies, as exemplified in the Georgia case, have added language to make clear that this needs to be your primary residence. Also, if you look at the examination under oath, a lot of the questioning to Mr. and Mrs. Peterson was trying to figure, the language used by the lawyer was that your main home? Was that your main home as a nuclear family? Clearly, this isn't the situation that fits into that nice, neat box of the home of the nuclear family. And this is an example that is probably fairly common when situations arise and you might not have one home as a nuclear family. And if you're the average lay person reading this policy, not lawyers or insurance company representatives, it's a reasonable understanding that if you're continuing to maintain a physical presence in this property so that you can stay there when you need to, that would satisfy the definition of reside in this policy. Finally, remembering the rules of construction, when the policy is liberally construed in favor of coverage, and when this record is viewed in the light most favorable to the Petersons, it's our position that this is just a fact question for the jury and not an issue of law for the trial court.
Well, let me unmute. Thank you very much. I appreciated the arguments this morning, and we